Okay. I'm going to call this meeting to order for the Polk County Board of Commissioners for Wednesday, November 6th, 2024. All commissioners are present. Announcements are on the agendas. Extra copies are in the back of the room. First item up on the agenda is comments for items that are not on the agenda, limited to 3 minutes. Good morning.
Randy Stroud, 611 Southeast Rosewood Lane, Dallas, Oregon. Right. From yesterday. So to Mr. Gordon, in the interview, you stated that you think that consistent dialogue between community members and law enforcement is key to improve services and build and improve trust. Why aren't you, as the Board of Commissioner, encouraging Mark Garten to do this? Mr. Gordon, if your statements are true from the interview you did in April of 2022, then it's your job to get involved and to have an educated opinion on this. Please stop pretending there isn't a serious problem with Sheriff Garten and his administration and their integrity and ability to run a professional law enforcement agency. Please stop playing politics and actually start working for your constituents who put their trust in you to do so. And I'll just state, it's far beyond investigation in our case. What happened to our family? Yes, it was terrible and awful. But this is an integrity issue within the office. This is a morale issue within the office. It goes far beyond just our one case. Are you listening, Mr. Gordon?
I'm listening.
Okay, thanks. So it goes far beyond just one case. It's a matter of integrity of the office. It's a matter of being responsive as a sheriff, speaking to your constituents, not gaslighting or ignoring or deflecting or any of those things. It's having the conversations, the hard conversations. We teach our kids to have those hard conversations if they mess up. We talk to them. We explain what's wrong, how to make it better, how to be honest, to have integrity. When there's a mistake made, you have conversations to hold that person accountable. I think we've talked about that before, Mr. Moorhurst. So by ignoring the problem, by not addressing the issue or saying you're going to, as he did in March 3rd of 22 with my dad and I, and then never responded again, that's unacceptable. Real quick, although it appears Mr. Garten has won the election, I just want to point out there was a statement made by Steve Warden on October 23rd, and it really stuck out. Integrity. It's what you do and who you are when no one's watching. It's the key to loyalty, the ability to admit mistakes, learn from them, and make things better. It's listening to the voice within and doing the right thing, even on the most treacherous path. I have high respect for this man. I don't have respect for Sheriff Garten until he starts communicating with his constituents. So I'll leave this over here and I'll just continue to come and ask questions. And because I'm not going away, it's going to be 3 years. I'll be the nagging, annoying mom that continues to come, but I'm showing my kids, I'm showing my family that.
Thank you.
You're welcome.
Any other comments? All right, seeing nothing further, we'll move on for approval of the agenda.
Also move. Second.
And moved and seconded. All those in favor signify by saying aye.
Aye.
Aye, passed unanimously. Approval of the minutes from October 30th.
I move approval.
I'll second that.
It's been moved and seconded. All those in favor signify by saying aye.
Aye.
Aye, passed unanimously. Approval of consent calendar.
Also move.
Second.
It's been moved and seconded. All those in favor signify by saying aye.
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 Aye, passes unanimously. And we have a second reading of Polk County Ordinance 24-06.
Thank you, Commissioners. So this is the second reading of the ordinance regarding the adoption of the towing policy of the Sheriff's Office is to be the policy of the county as a whole. The matter needs to be read in full prior to adoption, and so I will begin that process now. So in the matter of adopting an ordinance for the Polk County Sheriff's Office to provide fair and efficient guidelines for tows, ordinance number 24-06. Whereas the Polk County Sheriff's Office has adopted policy 502, which is attached as Exhibit A to this ordinance, a policy outlining the processes and procedures for towing vehicles. The Polk County Board of Commissioners hereby ordains as follows. Section 1, enactment, the Polk County Sheriff's Office 502 attached as Exhibit A and incorporated into this ordinance is hereby adopted as the Polk County tow policy. Section 2, severability. Should any section or portion of this ordinance be held unlawful or unenforceable by any court of competent jurisdiction, such decision shall apply only to the specific section or portion thereof directly specified in the decision. All other sections or portions of this ordinance shall remain in full force and effect. We'll now read policy 502, which is Exhibit A to the ordinance. Vehicle towing, section 502.1, purpose and scope. This policy provides guidance related to vehicle towing. Nothing in this policy shall require a member of this office to tow a vehicle. Section 502.2, towing services. The Polk County Sheriff's Office maintains contracts with qualified tow companies and utilizes the non-preference tow list when a vehicle is being held as evidence in connection with an investigation when it is otherwise necessary to impound a motor vehicle. This would include situations involving the recovery of stolen or abandoned vehicles, the removal from the streets of vehicles obstructing traffic in violation of state or local regulations, and when the need arises for a sheriff's office vehicle to be towed. Non-preference tow services. Upon proper application, the office may approve qualified towing services to be called when a citizen needs towing but has no preference as to which service to call. Tow contractors agree to arrive within 30 minutes of being dispatched. However, there are times when the ability to do so is outside of their control. It is suggested that deputies call to check the time of actual dispatch and or the estimated time of arrival before deciding to have another tow company dispatched. Any complaint alleging a violation of the agreement or other misconduct by a non-preference operator shall be referred to the sergeant assigned to tow contracts for investigation. The office may periodically review the performance of each authorized non-preference operator. The office will assist citizens by calling any tow company desired. If the citizen has no preference and requests towing services, one of the authorized firms shall be called in rotation. All deputies are specifically prohibited from directly or indirectly soliciting for or recommending any garage or tow service. Section 502.3, impound at arrest scenes. Whenever a person in charge or in control of a vehicle is arrested, it is the policy of this office to provide reasonable safekeeping by leaving the vehicle secured and lawfully parked at the scene unless the arrested party requests to arrange for someone to pick it up or they request the vehicle to be towed at their expense. Deputies should allow a reasonable amount of time for a person to arrive to retrieve the vehicle. While the Oregon revised statutes may authorize the impoundment of a vehicle for issues such as driving with a suspended license or revoked license, impounds are only authorized if, in such cases, leaving the vehicle would create a hazard or obstruction. An exception is for tows due to not having insurance, which is authorized by statute and policy. In all such cases where a vehicle remains at the scene, the handling employee shall inform the arrestee and note in the report that the office will not be responsible for theft or damages. Section 502.4, impounds related to criminal investigations. Vehicles that are needed for the furtherance of an investigation or prosecution of a case or are otherwise appropriate for seizure under ORS 133.535 may be appropriate for impound and storage as evidence. Generally, a warrant to seize a vehicle is required for impound to take place. The time needed to apply for a warrant to search a vehicle and not having enough personnel to monitor the vehicle in place is not in and of itself a reason to tow and store vehicles without a warrant. That being the case, deputies should consider if both the seizure and the search should occur where the vehicle is located, or if it is thought retention will no longer be necessary once completed, it can be done safely. State law requires the impounding deputy to take reasonable steps to protect against loss or damage to impounded vehicles and any contents that may have been taken as evidence. Deputies should make reasonable efforts to return a recovered stolen vehicle to its owner rather than store it, so long as the vehicle is not needed for evidence. If a recovered stolen vehicle is towed, the deputy shall share the owner's contact information, including the person's home address and telephone number, with the towing services that assumes control of the vehicle. Deputies unable to contact an owner while at the scene should make reasonable efforts to reach them at a later time to advise them of the recovery. Section 502.5, vehicle inventories. The contents of all impounded vehicles shall be inventoried in accordance with the following procedure. An inventory of personal property and the contents of open containers will be conducted throughout the passenger and engine compartments of the vehicle, including but not limited to the glove box, other accessible areas under or within the dashboard area, any pockets in the doors, or in the back of the front seat and any console between the seats, under any floor mats and under the seats. In addition to the passenger and engine compartment as described above, an inventory of personal property and the contents of open containers will also be conducted in the following locations. Any other type of unlocked compartments that are part of the vehicle, including but not limited to unlocked glove compartments, unlocked vehicle trunks, and unlocked car top containers. Any locked compartments, including but not limited to locked glove compartments, locked vehicle trunks, locked hatchbacks, and locked car top containers, provided the keys are available and are to be released with the vehicle to the third-party towing company, or an unlocking mechanism for such compartments is available within the vehicle. Closed containers located either within the vehicle or in any of the vehicle's compartments will not be opened for inventory purposes except for the following, which shall be inventoried, which shall be opened for inventory: wallets, purses, coin purses, fanny packs, personal organizers, briefcases, or other closed containers designed for carrying money or small valuables, or closed containers which are designed for hazardous materials. Other closed containers shall be opened in inventory if the owner acknowledges that they can contain cash in excess of $10, valuables, or a hazardous material. The inventory is not a search for evidence of a crime. However, deputies shall seize evidence or contraband located during the inventory. Items should be scrutinized to the extent necessary to complete the inventory. Tow truck operators are to receive a copy of the tow report. These inventory procedures are for the purposes of protecting an owner's property while in the sheriff's custody, to provide this for the safety of deputies, and to protect the office against fraudulent claims of lost, stolen, or damaged property. Section 502.6, vehicle searches. Case law regarding search and seizure is ever-changing and frequently subject to interpretation under the varying facts of each situation. Vehicle searches should be handled according to current training and a deputy's familiarity with relevant case law. Generally, a search warrant should be sought prior to conducting a search of the vehicle. Because circumstances under which a warrantless search of a vehicle might be permissible are very limited, and because vehicle searches are subject to many restrictions, deputies should, whenever possible, seek supervisory approval before conducting a warrantless search of a vehicle. Section 502.7, security of vehicles and property. After a thorough inventory of the vehicle has been completed and all contraband evidence and weapons have been removed, the deputy should make reasonable accommodations to permit a driver or owner to retrieve small items of value or personal needs such as cash, jewelry, cell phones, and prescriptions. If a search of a vehicle leaves the vehicle or any property contained therein vulnerable to unauthorized entry, theft, or damage, search personnel shall take such steps as are reasonably necessary to secure and or preserve the vehicle or property from such hazards. 502.8, release criteria. A vehicle impounded under this section shall be released to a person entitled to lawful possession of a vehicle upon compliance with the following: proof that a person with valid driving privileges will be operating the vehicle, proof of compliance with financial responsibility requirements for the vehicle, payment of the Polk County Sheriff's Office administrative fee, and any towing storage charges. A security interest holder in the vehicle is not required to comply with section A and B above and may obtain release by paying the administrative fee, towing, and storage fees. Section 502.9, records. Records section members shall ensure that pertinent data regarding a towed vehicle is promptly entered into the appropriate database. Vehicle storage report. Office members towing a vehicle shall complete a vehicle tow report. The report should be submitted to the records section as soon as practicable after the vehicle is towed. Notice after a tow. Within 48 hours, excluding weekends and holidays of a vehicle being towed, it shall be the responsibility of the records section to send a notice of tow to all registered owners and others having a recorded interest in the vehicle. Notice shall be sent to all individuals by certified mail. The notice shall include that the vehicle has been taken into custody and towed, the identity of the appropriate towing authority, and the statute, ordinance, or rule under which the vehicle has been taken into custody and towed. The location of the vehicle or the telephone number and address of that authority will provide that information. That the vehicle is subject to towing and storage charges, the amount of the charges that have accrued to the date of the notice, and the daily storage charges. That the vehicle and its contents are subject to a lien for payment of the towing and storage charges, and the vehicle and its contents will be sold to cover the charges if the charges are not paid by a date specified by the appropriate authority. That the owner or possessor or person having an interest in the vehicle and its contents is entitled to a prompt hearing to contest the validity of taking the vehicle into custody and towing it, and to contest reasonableness of the charges for towing and storing if a hearing is requested in a timely manner. The time within which a hearing must be requested and the method for requesting a hearing, and that the vehicle and its contents may be immediately reclaimed by presentation to the appropriate authority of satisfactory proof of ownership or right to possession, and either payment of the towing and storage charges or the deposit of a cash security or a bond equal to the amount with the appropriate authority. And thus ends my reading of ordinance 24-06. That being the second reading, the board is free to adopt it at this time if they so choose.
I'll make a motion that we accept Polk County ordinance number 24-06.
I'll second that.
It's been moved and seconded for adopting ordinance 24-06. Any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye, passed unanimously. Thank you, Mr. Smith. Are we going to have a need for an executive session?
No, sir.
No, sir.
So I do have an add-on then. Mr. Hanson, can you give us just a brief snapshot of our success, failures, hopefully all success yesterday and last night of our election process on behalf of our clerk, who I'm sure is very tired today.
Well, would have been more tired if you had to have every ballot counted before you had to leave, unlike because of postmarks and that. Now that's not a requirement. Everything went very smoothly. I don't think we had any incidences at any of our drop boxes or anything like that. we had a little trouble opening up the West Salem one. Mr. Matt had to drive over and
Use his magic fingers.
unlock the drop box. We had very high voter turnout. You'll continue to get a lot of mail today. They don't deliver mail on Tuesday down here, so we'll get a big batch of that. You'll get batches from the other counties also, and then all the ones that have been postmarked by yesterday come in throughout the week. So there's probably, I think they've verified about 70%, 65 to 70%. You'll get up to almost the 80% that is normal during a presidential election. I think we counted 35,000 ballots now. So a good chunk of them in. I don't think any races are really going to change statistically. County races won't change. Obviously, we're one small portion of the Temecula bond, but that looks like it's failing in all three counties, Polk and Marion. All money measures failed with the exception of Falls City School District. And I look statewide, almost all money measures failed, period. Very few. Mayor race in Dallas is somewhat tight. And then the city council in Dallas is somewhat tight. But overall, there were no issues. The voting machine worked great. The boards, we had plenty of workers there. You just can't deal with the volume that you get on election day to get it all caught up, because you get it at 8 or 8:30, all the drop boxes are delivered, and then you would have to verify signatures, slice envelopes, have the boards, and then run them through the machine. You wouldn't have got out. You might be still there if you had to count all ballots before you could leave. Overall, good process. Kim did well in her very first major election. You don't want to have those very often, though.
Yeah.
They're stressful, and I think the observation went pretty smoothly too. And overall, very positive.
Okay.
My back's a little sore, but that's okay.
Drop boxes and lines by 8 o'clock. No issues.
No issues have had in the past, but I don't think there were any this time. So people at least got it in before the last minute. But there were a lot of people. If you'd have gone upstairs in the middle of the day, there were 10, 15 people in line trying to get a ballot or those things. So there's still a lot of election day activity.
So the people that signed up to be the observers, understand they were told they couldn't observe after yesterday? Are you familiar with that at all?
I don't know if that's true or not true. That would be a Kim question. What they observed for the past 10 days isn't going to change
Exactly.
in the future. So I don't know if she denied that or not. It's going to be, she's not going to call in boards. Like, it's not going to be a continuous thing. So for the observer, you may see him do signature verification and take the trays to the back, but you're not going to see the whole process moving.
Yeah, the next major issue would be whether or not we get a recount request.
Right now, there's nothing that would require a mandatory recount. But not all
You can
the
get
ballots
one.
are-
They're still eligible potentially to get a computer drawn recount from the Secretary of State's office.
You can do that. You can also, the Secretary of State, just as audit purposes or whatever, give you 1 or 2 or 3 things that they have you do recounts on, just to make sure what you have reported matches what you have in reality. But I don't know the answer to whether the observers can observe, so that'd be a Kim question.
Excellent. Well. Happy for that. Anything else? All right, hearing nothing, we are adjourned.